Major USCIS announcement, I-130 family visa rules starting November 2025. That's right, a brand new immigration update has just been confirmed, and it's one that could completely change how family visa petitions are handled from this November onward. If you're sponsoring a spouse, parent, child, or sibling, this update directly affects you. The USCIS has officially revealed major adjustments to the I-130 process, the core petition that connects U.S. citizens and permanent residents to their loved ones abroad. And according to insiders, these changes could mean longer timelines, stricter document checks, and a completely new way applications are prioritized. For thousands of families, this isn't just another paperwork change, it's the difference between being together in a few months or waiting years. Immigration attorneys are already warning applicants to prepare now, because once November 2025 arrives, every new I-130 petition will be reviewed under updated rules. Some of these adjustments might even apply to pending cases, which means if your petition is already in progress, you could still be affected. The USCIS says the goal is to make the system more efficient and transparent, but many are calling it a double-edged sword. On one hand, the new digital processing system could speed up certain approvals. On the other, new verification and background procedures might slow things down for others, especially for those missing even a single document or small detail. So if you're in the process of bringing a loved one to the US, this announcement should have your full attention. We'll be breaking down exactly what these new rules mean, what to expect in the next few months, and how you can prepare before the changes take full effect in November 2025. Don't skip this, it could save you months of delay and a lot of frustration. If you care about staying one step ahead on immigration updates that directly impact families, make sure to like this video right now. Your support helps more families get the information they need before it's too late. The announcement from the U.S. Citizenship and Immigration Services has caused an immediate wave of attention across immigration circles, both in the United States and abroad. Officials have described this as one of the most significant updates to the I-130 family petition process in nearly a decade, and the reason behind it, they say, is to modernize and streamline family-based immigration for the digital age. Yet, while the intent may sound positive, the real question remains: will these changes actually make things easier for families, or will they introduce more hurdles? That's what we're going to unpack in detail today. The I-130 form, known officially as the Petition for Alien Relative, is the foundational step for U.S. citizens and lawful permanent residents who wish to bring close family members to live in the United States. It's the first door that opens the path to family reunification, a step that thousands of households depend on every year. But starting November 2025, the USCIS is revising both the review framework and processing sequence for these petitions, and this could reshape how long families wait, how cases are prioritized, and even what kind of supporting documentation is required at the time of submission. Now, what exactly is changing? According to USCIS officials, the most notable shift is the introduction of a new digital-first evaluation model. This means that every I-130 form submitted after November will be processed through a fully integrated online system that uses both human officers and automated verification tools to check data consistency, financial eligibility, and identity proof. In theory, this should help reduce manual backlogs. However, early reports suggest that the system will also flag applications for enhanced scrutiny if any detail, even a minor discrepancy, does not match other federal databases such as IRS, SSA, or DHS records. This is where things could get complicated for families. In the current system, an officer might review your case and ask for clarification through a request for evidence, giving you time to respond. Under the new digital model, the initial review will be much faster, but cases flagged by the system might face automatic delays or be moved into secondary review queues. This could mean that applicants who are unaware of small inconsistencies like mismatched names, addresses, or income documentation could experience longer processing times without understanding why. USCIS has stated that the aim is efficiency and fairness, but several immigration experts are urging applicants to double-check every detail before submission, especially in joint sponsorship cases or where supporting documents come from different family members. They warn that what might have been a minor issue before could now lead to months of delay. In addition to digital verification, another major change involves the processing order. Under the old system, I-130 petitions were largely processed on a first-come, first-served basis within specific service centers. Starting November 2025, USCIS will transition to what they are calling a dynamic workload distribution model. In simple terms, petitions will be automatically routed to whichever service center has available capacity, instead of being tied to one regional office. This could, in theory, speed up processing for certain applicants, but it also raises questions about consistency. Different service centers have different approval rates and slightly different interpretations of documentation, so this change could lead to uneven outcomes depending on where your petition ends up. There's also a shift in how USCIS intends to communicate updates. The agency plans to introduce a new online portal where petitioners will be able to see real-time status updates, including which stage of review their case is in and any notes added by officers. This feature is being welcomed by many immigration advocates, who have long criticized the lack of transparency in the current system. But it also comes with added responsibility. USCIS expects petitioners to actively check their accounts for updates. If a request for evidence or clarification notice is issued, applicants will now have shorter deadlines to respond, possibly within 15 days instead of the usual 30 to 60. This accelerated response timeline could catch some families off guard, especially those living abroad or working with limited internet access. Another crucial part of this new rule is the financial verification process. The I-864 affidavit of support, which is required in most family-based cases, will now be cross-checked with IRS tax transcripts automatically. This means that petitioners who have discrepancies between their tax filings and the income reported on their support affidavit could face immediate holds or even rejections. USCIS officials say this change aims to prevent fraud and ensure that only financially capable sponsors are approved, but it also raises the stakes for accuracy. Families who rely on joint sponsors must make sure all income and documentation match perfectly, or they risk being flagged for additional review. The new rules also touch on eligibility categories, particularly for stepchildren, adopted children, and siblings. Under the updated framework, applicants in these categories will be required to provide additional relationship verification documents up front, such as proof of continuous contact, shared residence records, or adoption decrees verified through local authorities. While this is meant to strengthen the legitimacy of applications, immigration attorneys warn that it could make the process significantly more complex and time-consuming, especially for families in countries with limited access to formal record-keeping systems. Beyond these procedural changes, the USCIS has hinted at a major policy update concerning backlog management. Currently, the agency faces hundreds of thousands of pending I-130 cases. To address this, they plan to introduce what's being called a priority lane system, where certain petitions such as those involving U.S. military families or urgent humanitarian cases will be processed on an accelerated track. While this sounds promising, it also implies that standard petitions might experience slower progress as resources are shifted toward the new priority queue. Critics of the announcement are already voicing concerns. Some argue that these reforms, while presented as modernization, could end up favoring applicants with better access to digital tools and legal assistance, leaving others behind. They worry that the automated verification system could introduce errors that are difficult to appeal, especially for applicants who don't fully understand the new online workflow. Others are skeptical about the promise of faster results, pointing out that similar modernization efforts in the past have sometimes led to more confusion rather than clarity. However, not all feedback has been negative. Several immigration advocacy organizations have praised USCIS for taking steps to improve transparency and reduce fraud. They believe the new tracking tools and digital processing features could empower applicants to better understand where their petitions stand and reduce the uncertainty that has plagued family visa processing for years. For those who have experienced months of silence from USCIS after submission, even the smallest increase in visibility will feel like progress. Still, for applicants, the most pressing question remains: how will these changes actually impact real cases starting November 2025? Let's take a closer look at what this might mean for different types of petitioners. For U.S. citizens petitioning for their spouses or children, the new digital workflow might streamline document verification, but it could also introduce stricter checks for relationship authenticity. Officers will rely more heavily on digital evidence, such as joint financial accounts, communication history, or shared property documentation. This means that couples or families who haven't maintained thorough records of their relationship might face additional scrutiny. For lawful permanent residents, the new system could be both a blessing and a challenge. On one hand, petitions filed electronically might move faster through the initial intake process. On the other, increased automation could make it harder to explain unique family situations, for example, where a petitioner recently changed jobs or income sources, or where family documentation comes from multiple countries. Immigration lawyers recommend preparing detailed supporting letters and ensuring all translations and notary seals are clear and consistent. Another area of focus is communication and appeals. USCIS has confirmed that with the digital rollout, all correspondence including requests, rejections, and appeal options will be issued electronically first. This is intended to speed up delivery, but applicants will need to be extremely attentive. Missing a notice or failing to log in regularly could result in a missed deadline. For this reason, applicants are being strongly advised to keep their contact information updated at all times and enable notifications for USCIS emails or text alerts. There's also a growing discussion about data privacy and security. Because the new system will rely on cross-agency data verification, concerns have been raised about how personal and financial information will be protected. USCIS has stated that all data transfers will be encrypted and compliant with federal cybersecurity standards, but advocacy groups are still calling for independent audits to ensure sensitive family information isn't exposed or misused. Another significant point that many applicants overlook is how these updates may impact consular processing abroad. Once the I-130 is approved by USCIS, the case is transferred to the National Visa Center, NVC, and eventually to a U.S. embassy or consulate for the visa interview. While USCIS handles the initial approval, the embassy has the final say on visa issuance. With digital records being shared more directly between agencies, applicants can expect embassies to have access to more detailed data, which could lead to additional questions during the interview phase. Officials from the Department of State have already begun preparing for this transition, noting that the integration will allow them to review petition data earlier in the process. This could potentially shorten the time between USCIS approval and interview scheduling, but it also means that inconsistencies between the petition and the interview documentation will be caught much more easily. Applicants should ensure that every piece of information from dates of birth to marital history matches exactly across all forms and records. As for timelines, USCIS has not provided exact projections for how long the new process will take. However, internal memos suggest that the average I-130 processing time could initially increase as the system transitions and officers are trained. Once fully implemented, the agency hopes to reduce average wait times by 15 to 20% by mid-2026. Whether that target is realistic remains to be seen. Financially, the agency has not announced any fee changes tied directly to the new rules, but given the ongoing discussion about USCIS funding shortfalls, experts believe a modest filing fee adjustment could follow in early 2026. Applicants planning to file soon are being encouraged to submit before any potential increase takes effect. At this point, it's clear that these new I-130 family visa rules mark a turning point in U.S. immigration administration. For families, it's both a challenge and an opportunity, a chance to take advantage of faster digital systems, but also a reminder to be more diligent than ever. The best preparation involves careful documentation, consistent record-keeping, and a full understanding of what USCIS expects under the new guidelines. In the coming weeks, the agency is expected to release more detailed guidance, including examples of acceptable supporting documents and instructions for using the new online portal. Immigration professionals are advising families not to wait for the last moment. Instead, they should begin organizing tax documents, relationship evidence, and identification records now, ensuring that everything is ready before the November 2025 start date. As we move closer to implementation, one thing is certain: this update will reshape how family petitions are processed for years to come. For every family hoping to reunite in the U.S., understanding these changes could make the difference between a smooth approval and a frustrating delay. So, as always, stay informed, stay prepared, and if you found this breakdown helpful, please take a moment to like this video. It helps us reach more families navigating the same process, and ensures that everyone gets the accurate information they need before these changes take effect.